In North Carolina, there are three different types of small estate filings that can be made when the estate of a deceased individual is not substantial in value. The first and most common is what's called the application and assignment of years allowance, and it applies to a surviving spouse or surviving minor children of a deceased individual. It's a two-page filing that's submitted to the clerk of court in the county where the deceased passed away, and it allows for an assignment of personal property up to certain thresholds to be done immediately to either the surviving spouse or minor children. The surviving spouse can petition for up to $60,000 under the application and assignment of years allowance. Minor children can petition for up to $5,000 per child. The parent of the child is usually the one that petitions and receives that property. Another version of a small estate is called the affidavit for collection of personal property. This is generally for non-spouses. It could be for a parent who has passed away and leaving assets to a child. It could be siblings. It could be in addition to the spousal allowance. But it generally applies to personal property worth $20,000 or less in value. It is again, two-page filing that is submitted with the clerk of court, but it has a closing affidavit as well. So generally within 90 days, a affidavit of closure basically is submitted showing where those assets went, the ones that were collected and then distributed. The third is what's called summary administration, and it's only reserved for surviving spouses. It allows for the assignment of the entire estate of a deceased spouse to be made to the surviving spouse with all liabilities and encumbrances. So this is distinct from the spousal allowance, which transfers personal property free and clear of creditor claims. The summary administration takes all assets, regardless of the value, subject to all creditor claims.